To further clarify summary judgment, the object of summary judgment procedure is to cut through the parties' pleadings to determine whether trial is necessary to resolve their dispute. So I love civil procedure. It was one of my favorite courses in college. So where we break down the complex legal concepts into clear, digestible discussions, today we're covering summary judgment motions, a critical tool for parties seeking to resolve cases without going to trial. So we kind of explained what is a summary judgment motion. And like we said before, a party can move for summary judgment when they believe that the opposing party has no valid claim, no valid defense. Essentially, the moving party argues that there's no genuine dispute of material fact and that they're entitled to judgment as a matter of law. Under California law, this motion can be made anytime after 60 days from the general appearance, or even earlier if the court grants permissions. So let's talk about the timing of service and the requirements so you don't miss any deadlines. So notice in supporting papers, the motion and all supporting documents must be served on all other parties at least 75 days before the hearing. If served by mail, this period extends 5 days for California addresses, 10 days for addresses in the U.S. but outside of California, and 20 days for any international addresses. Now, if served overnight, add 2 court days, okay? Hearing deadline. The court must hear the motion at least 30 days before trial, so unless it orders otherwise. Filing motion does not extend the deadline. For responsive pleadings, so don't assume that just because you get more time to respond, just because you filed the motion. So just make sure that you're keeping all these dates calendared. And if you have a software that you can send notifications, I would do that as well. So as you should well know, a summary judgment motion isn't just a legal argument. It must be backed by the evidence. So the moving party needs to submit affidavits of declarations, answers, interrogatories, depositions, judicial notices. Crucially, the motion must include a separate statement of undisputed material facts with references to supporting evidence. If the moving party fails to do this, the court may deny the motion outright.